Patriots, the Supreme Court just granted review to a case that could redefine who is protected by the Second Amendment. And the Trump DOJ is arguing that the government can permanently strip your gun rights, not for committing violence, but simply for using substances the federal government doesn't like. We're talking about U.S. v. Hermani, the case that forces the Supreme Court to answer, who are the people protected by the Second Amendment? Does it mean everyone unless proven dangerous, or only law-abiding citizens as defined by the government? The Fifth Circuit ruled in favor of gun rights. Now the Trump DOJ wants the Supreme Court to reverse that decision and uphold federal gun bans on drug users. Before we break down this critical case, smash that subscribe button. We're covering Supreme Court cases that define constitutional rights. Let's hit 1 million subscribers. Let's dive into this prohibited person's case. Who is Mr. Hermani? Let me be blunt from the start. Mr. Hermani is not a good plaintiff for gun rights. This is exactly the type of bad facts case that gun control advocates love to push to the Supreme Court. When the plaintiff has terrible facts, it's easier for courts to rule against gun rights. Here's Mr. Hermani's background. Dual citizen, U.S. and Pakistan with close ties to Iran v. Investigation in 2019. Border agents searched his phone and found communications suggesting potential fraud on behalf of people tied to Iran and extremist groups. Family connections. His brother attended university in Iran, raising additional FBI concerns. Drug activity. Evidence he was both using and selling illegal substances, marijuana and cocaine. FBI raid. The FBI obtained a warrant, raided his home, and found a handgun marijuana cocaine mission. Hermani admitted he occasionally used substances and that the drugs found were his. Because of this, he was charged with violating 18 U.S.C. 922 G3, the federal law that makes it a crime for unlawful users of controlled substances to possess firearms. This is a terrible plaintiff. He has Iran connections. Drug dealing allegations. Admitted drug use. Compare this to Hunter Biden's case, where the focus was on a single false statement on a form. Hermani's case involves much more problematic facts. The lower court despite the terrible facts, Mr. Hermani filed a motion to dismiss, arguing that 922 G3 violates the Second Amendment after Brune and Rahimi. And shockingly, the district court judge agreed. The judge dismissed the indictment. The DOJ appealed to the Fifth Circuit, and the Fifth Circuit affirmed the dismissal. Here's what the Fifth Circuit ruled. The rule, Federal Law 922 G3, can only be applied to someone who is actively intoxicated at the time they possess a firearm. If someone uses drugs occasionally but is sober when they possess a gun, the law cannot apply. The Fifth Circuit based this on their precedent and the historical tradition of disarmament. Historically, governments restricted guns from people who were presently dangerous due to intoxication or mental illness, but blanket bans on anyone who ever uses substances. No historical tradition supports that. So, the Fifth Circuit ruled. The government must prove Hermani was intoxicated when he possessed the gun. Otherwise, the charge must be dismissed. This was a huge gun rights victory, even with terrible facts. The Supreme Court grants REVIWW. The DOJ had one option left: petition the Supreme Court. In June 2025, the DOJ filed their petition arguing the Fifth Circuit got it wrong, and the Supreme Court granted certiorari. They agreed to hear the case. This means U.S. v. Hermani will be decided this term, likely with oral arguments in early 2026, and a decision by June 2026. The question before the court: does the Second Amendment protect only law-abiding, responsible citizens as defined by the government? Or does it protect ALL people unless there's clear proof they're presently dangerous? This is fundamental. If the government gets to define who counts as law-abiding, they can exclude anyone from Second Amendment protection. Used marijuana once in college? Not law-abiding. Speeding ticket? Not law-abiding. Unpaid parking tickets? Not law-abiding. The government's definition of law-abiding could swallow the entire right. Trump DOJ's ARGOMIANT TSD Trump DOJ filed their brief arguing the Supreme Court should uphold 922G3 and reverse the Fifth Circuit. Here are their main arguments. Argument number 1, historical tradition of disarming dangerous people. The DOJ argues history supports disarming people considered dangerous, including habitual drug users. They point to colonial era laws restricting guns from intoxicated persons, 19th century laws targeting the mentally ill vagrancy. Laws and civil commitment statutes, they claim, these show a tradition of status-based disarmament. Argument number 2, not a permanent ban. The DOJ argues 922G3 is not a lifetime ban. If someone stops using drugs, they regain their gun rights. Therefore, it's just a temporary restriction. But here's the problem. The law doesn't say while actively using. It says unlawful user, which could mean anyone who ever used. Argument number 3, circuit split. The DOJ highlights that different circuits have ruled differently on this issue. Some circuits uphold 922G3 broadly. Others require active intoxication, like the Fifth Circuit. The Supreme Court needs to resolve this split. Argument number 4, pattern of behavior, not momentary intoxication. The DOJ's most important argument, historical disarmament, was based on status and pattern of behavior, not moment-by-moment impairment. They argue vagrancy laws, civil commitment, and insanity regimes restricted rights based on who someone was, not what they were doing in that exact moment. Therefore, habitual drug users can be disarmed during sober intervals, not just when actively high. The danger of bad PLINTIF, Fesley me explained why this case is so dangerous, despite the Fifth Circuit victory. First, terrible facts. Hermani has Iran connections, drug dealing allegations, and admitted drug use. The Supreme Court could easily rule against him without affecting normal Americans. CCOND narrow ruling, just like Rahimi. The court could issue a narrow ruling that says 922G3 is constitutional as applied to Hermani's specific facts. This would uphold the conviction without broadly addressing the constitutional issues. Third, bad dicta. Even if gun rights technically win, the court might include language about reasonable regulations or dangerousness that lower courts will use to uphold other gun restrictions. Remember Rahimi? The court said domestic violence restraining orders can trigger gun bans. Lower courts are now using that language to uphold all kinds of restrictions. Fourth, slippery slope. If the court says drug users can be disarmed, what about alcohol users? Prescription medication users? Anyone with a nice substance in their system? The line drawing becomes arbitrary. FIFTH government definition. If the government gets to define law-abiding, there's no limiting principle. They could exclude entire categories of people from constitutional protection. This is why bad plaintiffs with bad facts are so dangerous for constitutional rights. What the people may ask the core question in this case is, who are the people protected by the Second Amendment? Government view. The people means only law-abiding, responsible citizens as defined by the government. Anyone who violates a NI law can be excluded. Gun rights view. The people means ALL persons unless they're proven to be presently dangerous. The default is constitutional protection, not government permission. This isn't just about drug users. This affects medical marijuana users. Many states have legalized medical marijuana. Under 922G3, these patients are federal criminals if they own guns. Prescription drug users, many prescription medications are controlled substances. Should users lose gun rights? Past drug use. Should someone who used marijuana in college permanently lose rights? Alcohol users. If drug users can be disarmed, why not alcohol users? Alcohol causes more violence than marijuana. The principle at stake is, can the government strip constitutional rights based on status rather than conduct? The Second Amendment says the right of the people to keep and bear arms shall not be infringed. It doesn't say law-abiding people. It doesn't say government-approved people. It says the people. Likely OTCO may, based on the Supreme Court's recent pattern. Here's what I predict. Option 1. Narrow pro-government ruling. The court upholds 922G3 as applied to Hermani's specific facts. They say, given Hermani's Iran connections, drug dealing, and admitted drug use, he's not protected. This avoids a broad ruling, but doesn't help normal Americans. Option 2. Status-based disarmament. The court adopts the DOJ's argument that historical tradition supports status-based disarmament. They rule, habitual drug users, like the mentally ill and intoxicated persons, can be disarmed based on their status. This would be terrible for gun rights. Option 3. Fifth Circuit affirmed. The court agrees with the Fifth Circuit that disarmament requires present danger, not mere status. They rule, the government must prove someone is currently dangerous, not just that they occasionally use substances. This would be a major gun rights victory. My prediction? Unfortunately, I think we'll get option 1 or 2. The court will use the bad facts to uphold the law. But they might include dicta that lower courts will abuse to uphold other restrictions. What gun owner should kahana if you're a gun owner? Here's what you need to understand. First, if you use ANY, controlled substance including legal medical marijuana, you are federally prohibited from owning guns under 922G3. Second, this applies even in states where marijuana is legal. Federal law still prohibits it. Third, lying on a TF Form 4473 about drug use is a separate federal crime. Fourth, the Supreme Court's decision could either expand or limit who counts as prohibited persons. Fifth, watch for dicta and language in the opinion. Even if gun rights technically win, bad language can hurt future cases. Sixth, this case shows why we need good test cases with good plaintiffs. Bad facts make bad law. All right, Patriots, that's the complete breakdown of U.S. v. Hermani heading to the Supreme Court. Let me summarize. Supreme Court granted review to drug user gun ban case. Fifth Circuit ruled law only applies if actively intoxicated. Trump DOJ wants Supreme Court to reverse and uphold federal ban. Core question: who are the people protected by 2A? Hermani has terrible facts: Iran ties, drug dealing, admitted use. Court likely to issue narrow ruling limiting damage. Could still get bad dicta, hurting future cases. Decision expected June 22-6. This case will define who gets Second Amendment protection. Are rights for everyone, unless proven dangerous? Or only for government-approved citizens? If you found this valuable, smash that like button. Share with gun owners concerned about prohibited persons laws. Subscribe for updates when oral arguments happen. Comment: do you think the Supreme Court will side with gun rights or the government? Until next time, stay armed, stay informed, and understand that constitutional rights belong to the people, not just people the government likes. God bless America.